That is Officer William Wigger talking about what he had seen in that time. Now, I want to introduce my guest. We have Jason Friedman, a former prosecutor and currently doing civil litigation. Jason, welcome to the show.
Thank you, Brian. Nice to be here.
Great to have you. Now, you've been following the Jonchuck case. What is your initial thoughts before we jump into the next clip?
Listen, what else are they going to do? It's a given that this defendant did the actions that he's accused of doing in terms of killing his daughter. The question is, what was his state of mind at the time he did it? And that is the only thing that's going to be at issue with this case. So it's really fascinating to see the volley, so to speak, back and forth between the prosecutor, between the defense attorneys about what was his state of mind, and of course, whether or not he's going to be able to meet the legal definition of insane.
And I think volley is the perfect word as we're going back and forth through rebuttal witnesses. That's just a snippet of the cross-examination of Officer Andre Sosa. Now, Jason, what am I making of this? What information am I getting from here?
So what's happening now is on the cross-examination, don't forget, insanity, that's their only defense. So they are trying to elicit any testimony they can to show that at the time Mr. Jonchuck did this, he was not of sound mind. The interesting thing, though, is not of sound mind in the legal definition is different than sort of lay people, common sense, everyday definition. And so it's all about whether or not he knew right from wrong, whether or not he knew his actions were illegal, had that consciousness, that awareness of what he did was wrong.
I guess this is always a question that like when I started as a lawyer, and a lot of my friends always say, it's like, well, if he's in the hospital all this time and he's insane, why can't they just go up and say, well, he's in the hospital in the past, I heard this stuff about incompetent. So how do you bridge the gap between layperson's insane, or as we call as lawyers, mental disease or defect, and the actual legal standard? How do you do that as a lawyer?
Yeah, and that's a really, you just hit on one of the toughest things to do, because lay people will say, well, you got to be nuts if you're going to do something like that. He admitted it, everyone knew that he did it, but again, the idea is that it has to be a higher standard legally, otherwise so many defendants could then invoke, oh, I must not have been in my right mind if I were to do something as crazy as this. But the legal definition of insanity or not being mentally competent is about the awareness of knowing right from wrong. Being able to participate in your defense is another factor of it as well. But really at the time he committed that, was he aware of right and wrong? That's really the factor here.
Yeah. We've been following this case for a while. And like you said, I think volley is probably the best way of saying this. As we're getting to the point where we're seeing the prosecution come up and rest, and the defense rest, and I'm not sure how many, I've done very few cases where the prosecution has put in a rebuttal. What do you make of a prosecution putting up a rebuttal case?
I think they're really trying to, it's like another bite at the apple, so to speak, and really trying to cement their arguments into the minds of the jury to get them to say that although you might feel that he's not exactly, as a layperson mentally competent, under the legal definition, and that's what you swore to uphold, the law as a juror, that he does not satisfy the legal definition of being insane or mentally incompetent, and therefore should not be exonerated or found not guilty by reason of insanity in this particular case.
Exactly. So here we see a video, kind of in and out, looking down to the side, a lot of references of God, leaving things in the hand of God during a court proceeding. One would say, Jason, he looks crazy. Well, why is this a trial?
Yeah, I agree with you, but the question is legally whether or not he's crazy, as you say. Don't forget, there's a lot of people. It was that sort of easy to go before a judge and rant and rave a little bit and sound incoherent and act strange. I think a lot of defendants would be able to then invoke the insanity defense and potentially get off. So, in other words, it's not that easy. And that's why expert testimony on both sides is at issue in this case to decide whether or not, or so a jury can decide whether or not he meets the definition, the legal standard of being criminally insane at the time.
Yeah. And for those of you who've been following the case, you got to remember the question is at the time in which the action occurred. So you're going to see video of the first arrest. You're going to see actions before and after the incident actually occurred when this young girl unfortunately lost her life. But the question is at that point in time. Just so you know, there's a few things here that I actually want to focus on. Relying on self-reporting. Drugs have the ability to affect you. You don't know whether or not there's a mental disease or defect. And there's no actual drug testing. So we get all this information, Jason, and how reliable is this witness's testimony if we don't know whether or not Jonchuck had drugs in his system?
Well, I think he's very reliable, and I think that the prosecutor did an excellent job cross-examining this witness because he allowed this witness to set what the legal standard was and then asked him questions and got the witness to affirmatively acknowledge at least some of those factors were not present. I thought he did a really, really nice job on cross-examination. This is a powerful point, and I think it's going to certainly help the prosecution.
I would agree. I think this is one of those situations where you see, and again, this is the defense witness being cross-examined by the prosecution. When you have a great cross-examination, you actually have the ability to take your opposing counsel's witness and kind of make them your own.
Yeah.
Are you kind of seeing that here?
Yeah, absolutely. He was very weak on that, and to his credit, I guess he was testifying, truthfully into the facts. And he could not say, matter of fact, he affirmatively said that he appreciated the consequences of the action. Okay, namely that his daughter was going to die. The second prong of the insanity he elicited was did he appreciate the wrongfulness of his conduct? And that's where this witness was equivocating a little bit, but still didn't come out and say, no, he did not appreciate the wrongfulness of his actions. And so think about how that's going to, what's going to happen in closing arguments and how the prosecutor is really going to hammer that fact.
One question before we go on to the next video, though. Mixed messages, though, of understanding. I kind of picked up on that. What about that? How does that play out?
Listen, he's a defense witness, so he's trying to, certainly help his client on that. And but he was equivocating. That's the point. As you know, when you have an expert on your side, you want to make sure that there is no equivocation. You want that expert to be as strong and focused and really hammer those points. And that's enough. That's enough equivocation, I think, that a good closing argument can really help the prosecution here.
I hate to say it, but you got to give credit where credit is due. We were talking in the break. Prosecutors don't typically cross-examine, so it's kind of like seeing a wide receiver throw a touchdown. You're like, wow, that's amazing. And this prosecutor is making all of the big points. Jason, what am I missing here?
Yeah, no, you got it right on the spot, Brian. And you see how methodical he's being, calm, good tone. He's not raising his voice, and he's really getting good things out of this witness. That again, it's all about setting it up for the closing argument. And I just really commend him. I think he's doing a really nice job. It's interesting getting the. I like the word cherry pick. So he's already sort of tarnishing the opinion of this expert by saying, well, you're putting in your report things that are helpful for your client, but you're leaving out conveniently other things, namely a statement he made when he was 12 years old that if I ever get caught for something, I'm just going to claim it to be insane.
Yeah. I'm not a betting man, but I would say his calm and nice demeanor might stay at this cross-examination, but know that he's going to hammer hard during summation some of the great points that he made. But we'll get back to that after our break. I'm going to keep it simple. Jason, why is the lawyer doing this?
The lawyer's doing that because it's important for a defendant to be competent to stand trial. It has nothing to do with, like you said before, insanity at the time the crime was committed. This has to do with, can he follow the proceedings in court? Can he participate in his own defense? Can he aid his attorneys in representing him? And if he's not able to do that, you are incompetent to stand trial. Has nothing to do with being insane at the time you committed the crime.
So just procedurally, step one, lawyer steps up, raises these issues with the judge. The judge is going to be very weary of continuing, so they've got to say, you know what, pump the brakes. I know we've got a jury, I know we've got a case. Let's test to see whether or not he's competent. Let's see what they did to test that out. So there you have it. He's competent to stand trial. Jason, what do you think about the proceedings so far and what we've seen?
Yeah, well, based upon the testimony of the two experts that we heard, it certainly sounds like the judge came down with the right decision. I think the important thing to point out, especially for the viewers, is just how serious these allegations are about not being competent for trial, and therefore the judge is mandated to take these steps to make sure that the criminal defendant's rights are being adhered to properly. And they had one expert. The defense said, let's get another one. And the court said, okay, in the interest of overall completeness of it, let's get another court-appointed expert. It would have been interesting if one of the experts came out one way and one of the experts came out in the other way. The other thing I just want to point out, did you notice how the judge made the second expert, that Dr. Sciano, actually articulate on the record all of the different factors, very factually specific the details, so that the record is preserved. Anyone who might look at this decision, the judge's decision to find him competent to stand trial, now has a preserved record in case somebody's going to question that later on appeal.
Yeah, when I'm talking to young attorneys, I'm always telling them, when you're at trial, there's actually two judges. There's a judge you see in front of you, and there's actually one just kind of behind, a little above them. So you always want to be putting things on the record, make sure they're clear, because as you're saying, Jason, that might be reviewed. Now, as a defense attorney, you want to make sure, hey, I don't want my client to somehow regain consciousness or be competent down the road and be like, what happened the last couple of days? Yeah. The judge doesn't want to be appealed. And so, to your point, that's exactly why I was going run by run. Now, when I first saw this video, now, as you know, I'm a public defender. I was never a prosecutor beforehand, so my mind has kind of like only one thought. And when you look at this video, I think you can kind of cut it both ways. So Jason has agreed that he's going to put on his prosecutor hat, I'm going to put on my defense hat, and for you viewers, we're going to analyze this video from those two different perspectives. Jason, do the people go first, or do you want me to go first?
Oh, the people are going to go first.
All right, so people go first.
So, it's all about trying to get the defendant. That's why these are so fascinating. You're trying to get your case with the defendant's own words. It's almost like a relay race where the police officer, detectives go in, start the race, and hand the baton off to the defendant, hopefully hoping that their words are going to sort of finish the race. And if you saw, as they kept on delving in, they got some information and got some statements for her that I certainly think they can use to try to enhance their case.
See, this is the great thing about being a defense attorney and going second. I get to take his words and try to use them against him. Yes, it's absolutely, and I totally agree with you, Jason, it's a passing of the baton. But when they passed the baton to her, at least from a defense, they didn't get the, yeah, I did it. Yeah, I committed this crime. Yeah. There's actually a point, I think, earlier in this video where she actually says, I think I might need a defense attorney, but she actually volunteers to talk. Innocent people don't, it cuts both ways, but if I'm the defense in this case, like, innocent people claim up. Here she's giving you testimony, she's sad when they're telling you that the child is hurt. There's an affect, there's a change in this. Everything that you say that might point to guilt, I'm going to try to flip it and be like, this personality, no, this makes it actually turn into not guilty.
Right. And of course, we flip that back the other way, then saying, well, they have the goods on her, so, what else is she going to say? Yeah. She can't go in there and say, you're right, I did it. So she's careful about what she's saying. Maybe she is a decent actress, but that this whole thing is a charade to try to minimize or get herself out of big trouble.
Yeah. And I would bet money that you're going to hear some of the arguments that Jason made and probably some of the arguments that I made during summation. They're going to really hammer it through. And just like we see probably in politics today or in everyday life, one event can be viewed in two different ways. So just for a little clarity, this is not the actual witness who's testifying. This is the defense, Ms. Parton. It's my understanding, speaking to our producers, that Dr. Kathy McCaffrey did not want to be seen. That's why the camera is focused on the defendant here. Now, Jason, as the witness is putting on their credentials, obviously to be certified as an expert and be able to give their opinion testimony, what do you foresee us seeing here on the prosecution's rebuttal witness?
Just further clarification about what both the manner and what the cause of death is. And although it seems like a little mundane going through in great detail this doctor's credentials, it's going to be really important because, of course, the defense is going to be calling an expert witness of their own to rebut these opinions. And sometimes it really comes down to the credibility of each of those experts. And the prosecution wants to be able to say, look how well credentialed our expert is as compared to the defense expert. Notice she has this new subspecialty in pediatrics about child abuse and abuse. Really interesting.
Yeah, I'm glad that you got to that point because I was actually writing it down. It's this new subspecialty. It only started in 2009. She's one of the first to attain this certification, but to get that certification, at least 50% of your work needs to be in child abuse. Now, again, kind of going back to what you said before, a prosecution can take that and be like, she's a trailblazer. She knows information. She's one of the first to get this certification. She is probably the best person to talk to about child abuse. But as a defense attorney, he's like, science is kind of new. We're not quite sure.
Not only that, I would argue if I was on the defense side that she's going into it because all her training is in this area. So she's going in almost with a bias, looking to find that, yes, it is child abuse or is some abuse there. That's her bias sort of going into it rather than really being objective, analyzing all the data, and then coming to the conclusion. That's how I would argue that on defense.
And I think that's a great argument. I didn't even think about that. But that's one of the great things about being on this show. If the viewers aren't learning, I'm definitely learning from both our guests and our host here. Now, here again, we have the doctor kind of giving more qualifications. What do I do when this situation comes up? Children that are sent to us. But Jason and I were kind of commenting because we have this clear view of the defendant along with their lawyer. Jason, when you have a defense case and you have a defendant sitting there at the table, what kind of instructions do you give them while the case is going on and the jury is present?
It's always a difficult thing. You know, the one thing I'll start saying is you really have to be yourself, though. You know, jurors are going to see through. I always tell my clients, you know, you can't be somebody you're not. Okay, so obviously you're in a courtroom. Certain decorum needs to be adhered to. You can't have, you know, outbursts and things like that. What I would tell clients is just to remain calm, remain focused, but you have to be yourself. So you can't feign, you know, outrage or disinterest or something like that. Particularly with this defendant here, she seems very engaged. You know, she and her attorney seem to be looking at each other. It looks like they're writing notes to one another. So I think her demeanor is perfectly appropriate for the seriousness of the charge that she's facing.
Absolutely. Is there any coaching of prior to a witness testifying, you tell your client you're going to hear some salacious allegations. You might hear X, Y, and Z. Be prepared. No flailing, no outbursts. Is there kind of a coaching there as well?
Yeah, and I think you owe that to your client to obviously give him or her the heads up about what you expect to come out, how your reaction could, you know, negatively affect you. So you say, listen, this might come out. You're probably not going to be happy to hear it. It's part of the trial. Don't worry, we'll have our opportunity to cross-examine or present our own witnesses. We've heard the phrase, you got to keep your game face on, and I think that's really important for a criminal defendant.
Yeah. So I guess here's a bit of fun now because we're now actually working this case. If you were to grade the defense attorney based on how you see Ms. Petrin kind of reacting and collaborating with her attorney, as an outsider looking in, how would you grade how a jury might view her in this situation?
I give them a pretty high grade. It seems like they're, again, deferential, respecting the decorum of where they are in a court of law, but being very engaged. And that's the thing, really paying attention, writing notes to each other. And it shows me that the defendant herself is very, very engaged, and more importantly, really, really taking this seriously, which I think a juror is going to pick up on, and that can be an important factor when they're considering a close call.
Now, Jason, the prosecution already told us this. They told us this in their main case. They arrested. The defense went. They arrested. Is this not just bolstering what they've already said? What new information? Like, what is this?
Yeah, it's a great question, and in a way it is. And part of, as you know, when you're planning on doing a trial, that's one of the strategic decisions you have to make in the order of witnesses you're going to call, which witnesses you're going to call in your case in chief, which you're going to save for rebuttal if needed. And I think it's just a sort of, in a way, it's another bite at the apple, but it's really a great way for the prosecution to just bring home their theory of the case with supposedly a really, really qualified expert. You heard a lot of testimony about her qualifications. So I think to answer your question, it's really a strategic call, and the prosecutors figured out in their mind that this was the best way to deliver their arguments to the jury.
So as the witness is testifying, we are getting a description and an image of the amount of bruising, almost literally from head to toe, of this poor 3-year-old Hannah. And it leads me to believe, at least, Jason, either that's abuse by someone or that's a very tumultuous household that they're in, and what rugby game are they playing that we don't know about?
Yeah, no, certainly, a really, really detailed description. There was so many different photographs. You can hear the expert going through each one, identifying some of the bruising. But to your point, absolutely. But keep in mind, the ultimate question is to be the cause of her death and whether or not it was at the hands of this particular defendant. And even if there was other injuries, other abuse, other things going on in her household, the burden of proof is still to show that this defendant is the one who caused, not injuries, her fatal injuries.
Exactly. So again, this is a testimony from the expert talking about, and actually probably listing all of the numerous injuries that Hannah had. Jason, you first. I mean, as a defense attorney, I'm going to be there at the table with my head in my hand, being like, oh man, this is sounding really, really bad. But you had a great point in the break. Please share.
Yeah, sure. My point with Brian was that, yeah, there could be injuries, and there could have been injuries that this defendant caused, but that those injuries actually caused the child's death, Hannah's death. And that really is, the key to the case here. And so as a defense attorney, you want to know if there are other reasons, other causes where this could have happened. Keep in mind the time frame, my understanding, is very short. The kid was dropped off, and within 30 seconds to a minute, she collapsed, and the defendant's calling 911. Don't forget the father obviously had the child before that. So if I'm a defense attorney, I'm trying to explore other alternatives for the cause of these injuries.
So Matt, at least while I'm here in the studio, I'm kind of writing down a few things, and this is what I caught. I'm very curious as to what you think. She says, can't say without type of force, and quote, requires a scientific answer, the complexity of a human brain, you can't use models, but I'm relying on what I see from other children. She even gave like a great example. A child who falls from a second-story floor building and hits their head, I don't see the level of injuries from Hannah. And I heard a lot of the word expect, with no real conclusion as to the individual Hannah who's being in the question as to their cause of death. So Matt, what do I do with this when the witness can't tell me specifically about Hannah, but are using other models and just keep saying expect?
Well, I mean, the only opinion that she rendered to a reasonable degree of medical certainty was that Hannah would not be able to ask for donuts or walk around or talk soon after having an injury like this. Not immediately, but soon after. That's the only medical opinion that she rendered in this case.
Exactly, and to your point, and I kind of say it in tongue in cheek, the prosecutor kind of looking over their shoulder. Maybe that's why the defense isn't saying anything, not jumping up and down and objecting, because I don't see the knockout punch or the small punches that might help the prosecution to win their case. I think the defense might be able to walk out of this I don't want to use the phrase not too banged up and bruised, because that's kind of bad for the situation, but not too worse for wears, I would say.
The more I listen to this witness, the more I wonder why she's even testifying. Maybe for that bit of opinion right there that the child wouldn't be able to move around or talk or ask for donuts after this injury. But really, all that you need in this case is a forensic pathologist to come in and say this child had abusive, traumatic head injury, and that the child was in the care, custody, and control of the defense. What does it have to do with all these other bruises and things like that? Her cause of death was a traumatic brain injury.
Matt, great questions. I don't have the answer. We're asking them here in the studio as well. But the only way that you and I can find out, as well as our viewers, by coming back after the break.